Hello everyone, this is Neha Pellegrino, Senior MSP Compliance Counsel, and I wanted to take a moment to welcome you to the ECS on MSP podcast. As you all know, ECS is dedicated to assisting you navigate all the complexities of MSP compliance, but we believe that compliance shouldn't be static. The rules evolve, technology evolves, and the way people consume information evolves, which is what led us here. While we've been continuing to connect with you through our monthly webinars, which we love providing, we recognize that this industry moves really fast, and so do the professionals working in it. So the idea behind the podcast is about meeting you where you are by delivering content in a way that fits your schedule. And we're really excited to have this be a part of our ongoing commitment to share knowledge and support you. Each episode will bring you practical insights and real-world discussions, all in a format that's easy to listen to and easy to learn from, almost like you're sitting on the couch in our office. So whether you're here to stay compliant, deepen your understanding, or just hear from the voices that live and breathe this work every day, you're in the right place. That being said, let's get started.
Hi, everyone, and welcome. We hope that you've all had a wonderful day so far, and we're so glad you've joined us today for ECS's latest webinar, Demystifying Allocations. I'm Adriana Karner, Marketing Manager here at ExamWorks Compliance Solutions, and I will be your MC today. First of all, wanted to thank you all for taking the time to join us today. A little bit more information about our webinar series. Those of you who are regular participants of our webinars, you may know that we do this at least once a month, and it's a great way to connect and communicate with our friends and clients across the country. So we're very excited to be back and presenting for you all today.
Great. Thanks so much, Adriana. Yeah, I've really been looking forward to today's discussion because we're going to be talking about some really interesting topics. Again, for those of you that know the last time we had talked, that this will be available later on both YouTube and Spotify. So if you need to jump off early, please feel free to catch us later. But today's rundown is going to be MSA varieties, cost mitigation strategies, some submission hurdles, and then we have some real Q&As to go through, as well as any questions that you all might have if we have time at the end of this webinar today. So we'll jump right into MSA varieties. I think it's safe to say most of our listeners know what a Medicare Set Aside is or have at least heard the term MSA. But we toss that term around, and there's really so many different flavors, if you will, of MSAs. For example, a traditional MSA for the purpose of CMS review, an under threshold future medical allocation, or even an evidence-based MSA. So I have my, Shakespearean spin here, which is, at the end of the day, an MSA by any other name plays the same role, right? Which is the goal here is to safeguard Medicare's future interests by determining necessary future medical treatment. Also have indemnification listed here. So that's another offering, right, is an indemnified MSA. And here we're essentially warranting that future medical costs were calculated in such a way as to not shift the burden of post-settlement medical care onto Medicare, and in turn providing protection against Medicare denying coverage. So Marty, this is a topic that's been gaining a lot of traction lately. I know our listeners would love to hear some of your insights firsthand.
Yeah, so first of all, I mean, one of the things that has come up more and more over the course of the last, I would say 6 months, ever since CMS started down this path, right? Ever since CMS, or I should say, started down the path of asking for MSA values at the time of a WCMS or workers' compensation TPOC report, rather, in Section 111 reporting, is sort of like, why are we doing this? What's the basis for us to do this? Whether we submit the case or not, why are we doing this? And at the end of the day, if we're paying for medical all along, and then all of a sudden we stop paying for medical, and then the person is going to live another 20 years. The idea behind an MSA, whether it's a traditional, evidence-based, FMA, $0 MSA, whatever it is to illustrate to Medicare and to everybody what's the expected amount that would be paid by the comp carrier or a work comp employer for the rest of the person's life, right? So, and there's a sort of a thin statute, but then there's a pretty thick regulation, and then there's 200 odd pages of the WCMSA reference guide that help to illustrate that. But all of those things lead to that one question of like, well, how am I going to be protected if Medicare comes back to me in the future. And so that's where indemnification does come in. We've seen more requests for indemnification in the last certainly 6 months than we really have ever seen before. And one of the things that we're happy to talk about today, and one of the things that will, I'll just be completely candid and say, anticipate that we'll be able to release over the course of the next 3-4 weeks is, our indemnification program, which ECS has had for the last 7 or 8 years, has traditionally only been involving the evidence-based MSA program, which is we're creating an allocation, and then that allocation is being utilized by the parties, and then we'll cover basically whatever the difference is. Obviously knowing that we've taken an evaluation of that case and we've really looked closely at it. More and more over the course of the last few months, certainly we've had the requests to indemnify on zeros as well. Now, a huge part of that is because of the fact that CMS has taken away the opportunity to review the zero allocation. And so, Neha, this was a big deal when we looked at, started to examine what that might mean. July 17th of this year was a huge day for us, right? We're thinking about all of the different potential varieties of zeros that we've ever done or wanted to do, and yet CMS would be very narrow-minded in the way that they would evaluate those cases. They stopped evaluating them on July 17th, and they said simply, hey, listen, going forward, there's going to be the 4 varieties that we'll sort of talk about right here, but the question of indemnification on those cases is something that we've kicked around quite a bit, and I think that we're basically leaning towards, and I think that you could probably all on this line imagine that there will be categories of zeros that we will eventually over the course of the next few weeks announce an indemnification program for. But why are we doing that is big, right? So Neha, we can't say it enough. How many people have come to us in the last few months and asked us to do something with a zero that they never would have done before, and yet it's because CMS announced these changes in July. So couple things that we wanted to kind of cover here, just as background as to why we're indemnifying. And for you, really, like because you're on the front end and you see it, there were cases that CMS just sort of punted on because they were sitting there. So what's the sort of status of those cases that were pending review by CMS back in July for zeros? And then is it, what are the cases now that you're going to look at and say, hey, these are cases that should always be or could always be a zero that may never have been before just for whatever reason, but now they're the types of cases that we're evaluating?
Yeah, and so I think that was sort of the catalyst to all this, right? It was July 17th. CMS halted review of zeros. This was sort of a safeguard that a lot of the carriers were looking for was, okay, we'll go ahead and we'll take it and we'll get it approved, and then we know that we're good. And so they're looking for that assurance. They're looking to see, okay, well, how do we know that we're being compliant here when we have a zero? And again, CMS was very clear, not saying that zeros are inappropriate, but rather that, like you said, there's the 4 corners in which you need to stay within in order to have a zero be compliant. And so that's sort of where this was all born from, really, was we were sort of looking at those files. We knew what we were doing was correct. We knew what we were doing was accurate. How can we help all of you in making you feel secure in knowing that you're being compliant? And that's where the indemnified zero kind of came from. But going back to your original question, which was there were some zeros that were still hanging out, right? Because these files can be developed during submission and then they kind of get hung up there. So those particular files, it's a real question mark. They're still being reviewed from what we see because of the fact that they came in under the mark, right? They were submitted before that July 17th date. However carriers want to deal with them is however they want to deal with that particular file, right? Every claim's like a fingerprint. It's unique and it's nuanced in its own way. And so some have decided, okay, you know what, we're gonna settle. We know that we've taken Medicare's interest into account. We know that we've documented the file. Others have decided to play the development game back and forth. So it really just depends on the claim and the file. But that's sort of where we stand right now as far as zeros when it comes to any current ones that are hanging out with CMS.
Yeah, and so when we think about it, if you're going to indemnify, if it's whether it's going to be us or if you were to go with a competitor of ours, and is talking about indemnification, certainly this is a question that's come up, like as I said, more and more over the last few months. But the first question that a lot of people want to know is, well, what are you indemnifying? And typically an organization like ECS, if we are willing to indemnify, we're basically stepping in and we're saying, we've had an expert like Marty or Neha or one of our planners, if it's a medical case, look at that case and say that this is the anticipated future medical that we can expect in this particular case that falls within the four corners, as you said, of the WCMSA reference guide that is reasonable and appropriate, and it illustrates an amount that will consider Medicare's interest. You know, the difference between a case that gets submitted and non-submit and a non-submit case is just really that difference between what we think that Medicare may accept versus what will likely happen, right? And so, you know, that's probably the biggest difference here, and why organizations may be willing to indemnify is to say, hey, listen, we ultimately looked at this case. We have an expert evaluate it. The expert evaluated it based upon state workers' compensation law, what's happened in the past, and as you said, and I love this phrase, is the fingerprint, right? Like I never thought about it like that before until just now. So mark the day. November 18th. But that's a really perfect analogy. And it's like, if you're going to be the sort of fingerprint expert or the forensic expert who's going to look at that and sign off on it, you know, then you want to be willing to be able to say, hey, listen, there's more than just my say-so on this particular day. This is reasonable and appropriate, and parties can rely upon it, because all ultimately people want is that cost certainty. So one question that I had for you two around is just indemnification. Neha, this is a popular thing that it does tend to come up for us from time to time, is how long is that case good for? Whether it's a regular MSA and then transpose that with an evidence-based MSA, and then transpose that with how an indemnification process might work. So there's a big difference between, you know, like what's a good MSA and what's not, what's a stale MSA and what's not, especially when it comes to indemnification. So that might not be a bad thing to kind of like talk through here too.
Yeah, sure. So when you're talking about, you know, a traditional MSA, usually we say 6 months, right? Because that's what CMS is looking at. But when we're talking about indemnification, we're really going to truncate that. And so a lot of the time we're looking for those cases to settle. I believe it's 30 days. Correct me if I'm wrong, but these files need to move quickly in order for them to qualify. And so, you know, like you said, we can go back to the fingerprint. Every file is different, but we're going to be looking at each of these files to kind of fall within the qualifications that we have here at ECS, so that we can make sure that they're, you know, ripe for indemnification.
Yeah, and if it's like, I think that like up to 4 months for it can be indemnified.
Okay.
And the
Yeah.
data coming back, it has to be recently dated though, right? So, but
Yeah.
the report can be 4 months old, but the information has to be updated. So we do want to make sure that we have everything we need. But the other question too is like, and this is a big, you know, this I was dealing with this exact same issue today. Maybe we'll talk about it when we get to cost mitigation. But you know, those situations where, you know, you've got a partially denied claim, right? So the claim's accepted for, in this case, it was orthopedic, but it was denied for skin cancer. This is the case I was talking about today. In that case, they had recent orthopedic records, but they didn't really have any skin cancer records going back, you know, for several years, but it was part of the claim. And so one question around the submission process, and maybe you'll talk about this too in submission hurdles, but just forgetting about that, before we get to those things, just in terms of evaluating that MSA, right? Like it's hard sometimes to look at a case for traditional submission when you have partial records. You have great records for one of the parts of the claims, but no records for another part of the claim. So I don't know if what are some of the strategies that you wind up kind of dealing with essentially as a planner in that circumstance, or as someone who's asked to come in and evaluate, you know, what can we do in this particular case? We have some records, but not everything, and we want to submit this case, Neha.
Yeah, that's where, you know, that's where the hurdles come in, right? Because a lot of the time what we would say, what recommend is maybe to not submit. But if you are going to submit, there are certain things that you can do which would make that claim sort of it's almost like making it easier in CMS's eyes. So sometimes it may come down to separating claims out, not doing a global settlement, settling out the denied portion separately from the accepted portion. These are all, strategies that we've used so that we can make sure that when you're looking at a file as a whole, it's as complete as it can be when you're submitting, because again, CMS is going to glom onto what records you have, everything being current. They're not really going to take into account if you're saying, well, this is old, so we just don't have, we don't have the records that you need here. Then you'll be in that sort of development loop, which is kind of what we are looking to avoid when you're looking to submit files over to CMS for review.
Mm-hmm. Yeah, absolutely. So, one question that I have for the last point here that we have on this topic is around satisfaction of the MSP statute, right? And so last week I was speaking at a panel in Nashville, and that was one of the questions was, where in the MSP statute does it say that you have to, quote, consider and protect Medicare's interest? And the answer is it doesn't say where. There's nowhere in the statute itself that says you have to consider and protect Medicare's interest. It is Medicare's policy, and certainly the regulations say that Medicare will give deference to any allocation that the parties may make at the time of their settlement, such that they're not shifting the burden for post-settlement care onto the Medicare program.
Yeah.
And ultimately, that's all we're looking to do, right?
Right. I mean, again, that's really what it is. It's ultimately parties should ensure compliance with the Medicare Secondary Payer Act, which does mandate that the insurer or the carrier bear the cost as the primary responsible payer, right, for compensable medical expenses related to the claim. So the prominent vehicle to doing so would be the MSA, which is why we're talking about, MSA varieties, whichever variety best suits that particular claim.
Absolutely. Okay, so then we can move on to cost mitigation. And this is
Yeah.
where things get interesting, isn't it, Neha?
Yes, I do. I like this portion a lot. But speaking of MSA varieties, one type of MSA, which is the first bullet we have here, which has the added benefit of resulting in a lower MSA a lot of the times, is an evidence-based allocation. And these are different, it's a different term for this product. There are different terms for this product, but really EBMSA, evidence-based MSA, whatever you call it, utilizes evidence-based medical guidelines to project an allocation that identifies reasonable and appropriate care. So these types of MSAs can be submitted for review, or they can be non-submit MSAs. And in that same vein, when we talk about non-submit MSAs, such as a future medical allocation where the claim falls below threshold, sources such as IMEs or QMEs can be incorporated as a defensible means of explaining certain treatment recommendations, or even omitting certain treatment. And then, as we spoke about before, as Marty had mentioned, we do indemnify some of our EBMSAs, should that be something that you're interested in. I don't know, is there anything else you want to add to the evidence-based?
Well, the
Marty?
biggest question that I have really around the evidence-based piece is, when you talk about how like a QME, for example, in California, or an IME in New York would be utilized in an evidence-based MSA potentially, and then that's a huge difference from a traditional or standard MSA. And
Right.
so I guess the question that I always have, whether it's answering or questions that will often come up, is why won't CMS, when we have an IME or we have a PQME, right? Like we have like a really good report, why won't CMS understand that now that has sort of flipped the script in this case, and as a result, we're not responsible? Like, why doesn't CMS just abide by the IME, because it's state law usually that in some cases these IMEs do control?
Yeah, that's a great question. And it wasn't always the case, right? There was a time where these sort of evaluations were being submitted and were being reviewed and were being accepted and considered within, allocations that CMS was reviewing. And then CMS sort of flipped the script and said, you know what, we're not going to consider that because we don't feel as though this is something which really reflects the care or the treatment that, you know, the injured worker is receiving. So they have said that they're going to rely all heavily on the treating physician solely, saying that this is a provider which has consistent care, which, you know, sees the injured worker on a regular basis. They feel as though some of these independent medical evaluations may be biased, they could be bought opinions. And so that's sort of been their take on not considering medical evaluations as opposed to, you know, a treating provider's recommendation.
Yeah, and like I think that the other thing too about that, the evidence-based guide, when you think about evidence-based guidelines and the way that our team looks at it is sort of like that, you know, it's a difference in the standard that versus Medicare. Medicare looks at it and says, we're not going to sign an approval letter saying that X amount of dollars is appropriate to set aside unless we feel really confident. And so if there's a chance that a person's going to need a future treatment, whatever that treatment may be, then we're not comfortable just handing over a letter and handing the keys to future treatment if there's this chance that this person will need this future surgery. That chances doesn't necessarily have to be 50%. It could be a 20% chance that the person's going to need the surgery. They have to lose, you know, 100 pounds and quit chewing tobacco, whatever the case may be. Well, I mean, maybe they'll lose 100 pounds, but they won't quit to whatever that, you know, there's a lot that has to go into that, right? Versus when it comes to an evidence-based MSA, it's really evaluating the person from a whole body perspective and their medical treatment from a whole perspective and saying, okay, well, is there really a more likely than not situation here? Or is it less likely that they're going to have, you know, lost 100 pounds? Maybe it's easier now to lose 100 pounds than it was 10 years ago, but it's certainly like definitely like it's a thing that we have to evaluate as planners, you know, and then also our team, you know, certainly you and Michael Flower and Patty are always looking at that from the perspective of, are we willing to indemnify in these cases as well, right?
Mm-hmm. Yeah, for sure. And we will talk about, you know, kind of surgeries as we roll down some of the other topics that we have here in cost mitigation. But the next one, and a really big one, which we have a couple of bullet points under, is prescription drugs. So, you know, one of the greatest cost drivers in an MSA is the prescription drug exposure. And oftentimes the simplest savings opportunity comes from evaluating brand name medications and determining whether there's an equivalent generic available. So first topic we have here is brand versus generic. So when we prepare allocations in-house, we always review the medication list for any conversion opportunities. And if we obtain clear documentation from the prescriber, which supports that switch, along with an indication that the claimant has tolerated that switch, CMS will then recognize that generic cost. And so that's, you know, in the event that you are looking to then submit that over to CMS, that's what they'd be looking for. They'd be looking for, one, is there a clear indication or recommendation that the switch can occur? And then two, showing at least a 3-month period of the claimant tolerating that generic version in order to have that generic drug, you know, priced out by CMS. And then weaning, we can talk about I mean, this one is a really tricky one, I will say, especially if you're looking to submit a file to CMS. So we like to seek out opportunities for weaning medications that can pose long-term risks, particularly opioids, muscle relaxants, or you know, redundant medications that happen to end up on these sort of medication lists. And for this type of tapering, we can lean on those evidence-based guidelines like we just talked about, which are backed by clinical trials and peer reviews. However, in the event of CMS submission, CMS will rely heavily on the specifics within the treatment records. So again, I know we've talked about this ad nauseum, but CMS will take a snapshot of what's being prescribed at that particular time, and they will allocate the same medication at the same dosage at the same frequency over the course of the claimant's life. So in reality, the implications of this can be anything from addiction, organ failure, unlawful distribution of these drugs. So Medicare's interest aside, in the interest of making, these injured workers whole, return to work after an industrial injury, it's vital to incorporate this type of reasoning within your strategies. Now, for CMS purposes, phrasing such as needed, that won't suffice. So there really needs to be a demonstrated consistent weaning schedule within the medical chart, as opposed to simply stating an intent. I don't know if you agree with that, Marty. I know that the weaning or tapering can always be tricky.
So hard.
Yeah.
So hard because the demonstration by that of the treater can decide what they want to do, and then it's up to the person to actually fill it in the way in which you need to fill it. And that's really where it becomes so challenging, is like, and so from a you think about it from a claimant attorney perspective, right? If they are sort of thinking about it in the same way, like they're saying, hey, well, we want this person sure to reduce their prescription drug use so that they can get an MSA that's going to help us settle the case. Claim attorney has to be involved almost and say, what's happening? Are you actually feeling it that way or not?
Mm.
And so there's a lot of coordination that has to occur between both counsel on both sides, adjuster, PBM, you name it.
Yeah. And so what else do we have here? We have CMS pricing versus real world pricing when it comes to prescription drugs. So, another major factor is the gap that occurs between CMS pricing methodology and actual pharmacy costs, right? So CMS uses average wholesale pricing, which tends to be higher than the sort of contracted pharmacy rates that you can get. I think a lot of you have heard the term, PBMs, which are essentially negotiated pricing that carriers pay. So, what this means is that the MSA can reflect an inflated drug cost compared to what's actually happening at the point of sale. Now, of course, in the event of CMS submission, CMS is going to apply AWP pricing, right? So that's, Marty, you know that. We can't really, play with that too much.
No getting around it.
So, I think mitigating these costs really boils down to reviewing the medication list, ensuring that each one is accurate, updated, and prescribed in a clinically appropriate manner. I have seen where we are doing, evidence-based allocations or non-submit allocations. We can sometimes utilize those PBM costs or go through GoodRx, and that can sort of give a more accurate reflection of kind of what's happening at the pharmacy at that time. But outside of that, yeah. Go ahead.
And like when you're looking at submitting, right, and you're looking at the MSA, that you're like, whether it's prescription drugs or not, one of the questions that I had on the case I just dealt with earlier today was, well, when I look at the conditional payments, which is the amount that Medicare actually paid, I see that Medicare paid, $70,000 for what would have cost us $200,000. Why are we not in our MSA going in at that rate versus the cost that we would have paid? And the answer is very simple. It's that because when CMS evaluates it, they look at it from the work comp fee schedule rate and the AWP rate. There's no change to that. The AWP has been around for them since I think 2009, and the work comp fee schedule rate has been since the dawn of time when it comes to CMS submission. So there's been no change to that. But to your point, like when you have an evidence-based MSA, you can look at that and say, well, let's look at this from a real world perspective and say, what will that person really cost versus, if we were to submit that case to CMS and have CMS look at it. Would they be paying in New Jersey $430 per hour for physical therapy, or would they be paying a lower rate on the work comp fees? We don't know.
Right.
We can make those evaluations.
Yeah. All right, good. So our last bullet here is surgical recommendations, and this one's huge too. The presence of a surgical recommendation can dramatically inflate an MSA. So the first step really is to verify whether the procedure is medically necessary based on the injured worker's current status and if it's safe for the injured worker to withstand, right? So this is where those second opinions or evaluations can come in to confirm if a surgical recommendation is consistent with evidence-based guidelines, or even whether a less invasive alternative may be appropriate. The caveat here being that even a vague or an ambiguous recommendation will still be considered by CMS. So phrases to be careful about are things like if conservative care fails, or if symptoms worsen, or as a last resort. I've seen that, you know, so those are very sort of vague, kind of throw it out there recommendations, but CMS will, you know, as we know, they allocate under a worst case scenario mindset. So they're going to see that and say, so you're saying there's a chance, right? And then they're going to go ahead and want to include that in the allocation because they want to be covered for that. So these sort of phrases really leave the door open as a possibility, and then CMS wants to see those surgeries allocated. So clear and concise wording in regards to kind of clarifying those recommendations is really important. I am going to move on. So for those of you that are on this webinar today, you get a little visual. For those of you that are listening, I'll kind of walk through it. This is an actual example of a letter that one of our clients had gotten from a doctor. I've redacted, you know, any identifying information here, but this was unfortunate because I had to let them know that this wasn't going to work. The doctor here is sort of waffling back and forth between stating why, believe this was a shoulder surgery. First of all, why the surgery is being recommended, because it sort of starts with, well, it could be underlying degeneration, but the symptoms of this could have been related to a previous surgery, which was related to the work comp claim. So I am recommending this, but I don't know if she wants to get it, you know, and it's just all over the place. And so this is bait for CMS to say, yep, we're going to include this surgery. This is definitely possible. This is possibly related. And so again, statements or clarifying statements need to be clear, because any ambiguity is going to be sort of ripe for that to be included in the allocation. I feel like I bogarted this section a little bit, Marty, so I don't
No,
know if
this is perfect. Because
okay.
here's the reason, this is the thing, like this doctor, when you read the doctor's note, the doctor says there's certain, this is like the patented, it's almost like the law school exam of why CMS would say that they need to include it.
Yeah.
So the surgery could benefit her if she wanted to proceed with surgical intervention. But based upon my last visit, it appears she does not want to proceed with the surgical intervention. Therefore, I would place her with maximum medical improvement and recommend no further treatment. We see this all the time. This is the most common thing that we see from doctors, because the doctor doesn't want to change their recommendation. They'll say the person doesn't want to have the treatment, so therefore I'm not going to give the treatment. And if they don't want to have the treatment, then they're MMI. Well, CMS's classic response, and I think that it's probably in a bumper sticker somewhere in the Baltimore office, is, but they can always change their mind.
Yeah.
That's what they always say is, well, that's fine, but they can always change their mind. Or they don't want to have the surgery because of some crazy view that they have. Well, they could change their view, or they don't want to have the surgery, or they can't have the surgery because they have to lose, 150 pounds. Well, I just signed them up for Ozempic. So at the end of the day, like all of those things are possibilities now, and sometimes they can be far more possible today than they could have been, 10, 15 years ago. And as a result of that, that becomes a much bigger challenge for CMS to say, well, we're not going to sign off on it because what happens if the person changes their mind tomorrow and then we're stuck with the surgery? So you can understand it from CMS's perspective. So the question that I have for you is, so what are sort of like our calculus on when we see something like this from an evidence-based perspective? What's our calculus to decide, well, should we include or exclude that surgery? It's medically recommended. The person says they don't want it. What are some of the ways that we might look at to say, well, evidence-based, we're going to include it because of X, or we're going to exclude it because of Y?
Yeah. And And that's a great question because again, sometimes that'll come up, well, this is not being submitted, so we can just not include it, right? But when we are doing our evidence-based allocations, they still need to be based on evidence-based guidelines. They still need to be defensible. So the fact that a claimant says, I don't want the surgery, that doesn't qualify as being an evidence-based, clinical reasoning for not having a surgery. And so you're looking for things such as, a physician stating that this patient happens to be 85 years old and maybe will not be able to withstand another hip replacement, or like you said, they're not in condition right now to be getting it. Maybe it's due to the fact that they're a smoker, or maybe it's due to something else. And so sort of factoring in that person as a whole to say, okay, yes, could they use the surgery, but the surgery actually could end up causing more problems for them later. Those are the types of things that we would consider in.
That's like fingerprint analysis. You're basically
Yes,
the forensic analysis of the case, looking at it and saying, okay, well, sure, the doctor's recommending surgery kind of, but not really. What are the other objective factors apart from the subjective intent of the beneficiary? What are the objective factors here that we can look at outside of the four corners of this letter that's dated October 27th? Maybe the person's been recommended for surgery for 6 years and hasn't had it. Well, we're going to say, well, they're not going to change their mind, versus they just got the recommendation 2 months ago, right? So like there are a lot of those other factors that can kind of come in.
exactly. Yeah. Okay, I think we can probably move on to our next topic, which is submission hurdles. So again, submission of an MSA to CMS is a voluntary process. In doing so, there are, certain things that we can run into. A lot of the hurdles listed here have to do with a file being developed, after it's submitted. So CMS is very specific about the records that we need. I know we talked about that earlier. And so when you're, getting your file together and putting together a submission packet, you think you've got everything you need, and then you get that letter that stops you in your tracks, the development letter. And so one of the first hurdles that we have on here is in regards to medical records. And so they're always asking for 2 years of medicals. What does that mean? It doesn't necessarily mean the last 2 calendar years, because there are times where maybe treatment has stopped, 3 years back. So what they're looking for is the last 2 years of treatment. However, they want you to then, prove the negative and prove that that treatment stopped on, January 4th, 2023, by getting a letter from the doctor which states specifically the last date that I saw John Smith for his work comp injury was on this date. And so if you don't have that, CMS is going to come back around and say, show me what happened. Show me what's gone on between this date and that date, because we don't have anything. One of the other sort of sticky points is that applies to all conditions. So if you have someone that has a shoulder injury, an elbow injury, and then a knee injury, they want to see last 2 years of medicals for all of those. So if the sort of elbow treatment fell off, if you will, there's sort of a gap in treatment, or sort of this lack of continuity of care, you're going to get that letter and it's going to say, we're looking for the last 2 years of medicals. And you're saying, well, I sent that. But they're not going to be specific and say, we're looking for the last 2 years of medicals for the elbow, because really those development letters, they're pulling boilerplate language, they're popping that in and they're sending them out because they're sending so many of these out. And so really knowing your file, knowing what conditions there are, when treatment ended for those conditions, and if it ended early, making sure you're having specific letters for specific conditions is really vital for kind of clearing that particular hurdle there.
Yeah, now one thing that we do run into, and we have seen more and more this year, and it's continued it's been a sort of a snowball over the course of the last few years, is I think certainly a higher percentage of cases do get developed for, frankly speaking, BS, right? I mean, like we wind up seeing, development letters. It just almost seems like back, like we can say it now because the statute of limitations is long run, but there was a time 13 years ago where for 6 months, all they did was develop cases because they didn't want to review them, right? And so We both were there for that, so we can
Yeah.
say that that happened. That hasn't been happening now, but certainly, what we are seeing is that there are incidences or increased incidences of development letters, and CMS saying, hey, we want to review the case, but we need this additional information. That is really a great point that you bring up there, Neha, that if an adjuster really understands their file
Mhm.
and can say, oh, well, this is the most recent record that I have, and so tell me what more I need. And then honestly push back for somebody like me or you, or more likely somebody on our submissions team to say, oh, well, when I look at the file, we have that record. We have all the records that you're talking about. CMS just wants something to like kind of basically square the circle on this one thing. And ultimately that's what they're looking at, right? Is just squaring circles on each of the little injuries that that person
Yeah.
has, right?
Yeah. Yeah, exactly. Yeah, that's it. Um, I don't know if you have anything else in regards to development, but if not, we can move on to challenging decisions.
Perfect.
Perfect. Okay, great. So another part of submitting an allocation to CMS is sometimes we get a decision back that we're not thrilled with, right? So we can get what we call counter hires. Those can happen for so many reasons, right? Various different reasons. The question always is, what can I do about it now? So there are options for challenging CMS decisions. Two in particular, very similar in name, but very different in procedure. So we have reconsiderations and we have amended reviews. So the reconsideration comes where maybe there's an error on CMS's part. Maybe there was some sort of mathematical error. Maybe there was a record that wasn't reviewed. Again, these are human reviewers that are going over these files. So sometimes they come back and they've, used an incorrect frequency for one of the medications or what have you. So we can go ahead and submit a re-review or a reconsideration request, which will basically just point back to the records that were submitted within the original submission packet and say, please take another look at X record, which indicates that this medication should be allocated once per day as opposed to 3 times per day, as it was incorrectly allocated within your proposal. So those type of re-reviews or reconsiderations we can kind of go back and forth with as many times as we want. It's sort of like we can ping pong back and forth. If they say they don't agree, maybe we can, point to a different record or come up with a stronger, verbiage for them if we need to. But the amended reviews are different in the sense that these are decisions that are being challenged post CMS decision, where there's been a substantial change in treatment or maybe even just the status of the claimant themselves. The difference here being that there's really one bite of the apple here. So you get one shot at these. And it's really because CMS doesn't want to have to keep going back on decisions that they've already made to then sort of open a can of worms over and over and over again. Because if you think about sort of the way in which people heal or injuries can be aggravated or anything like that, someone's status can change over the course of time, many different times, and they don't want to have to keep going back on that every time someone's status changes. So it's really, really, really vital for these amended reviews that we have everything that we need first time, because there's no development there and there's no back and forth. You get one shot, and if you didn't do it right, you're done there. But some examples of why we would do an amended review would be, perhaps there was, a recommendation for a spinal cord stimulator, or perhaps there was a surgical recommendation or anything like that. And, 6 months down the line, it turns out they don't actually need that procedure, which can be pretty pricey. We can go back, and what we essentially do is create a whole new MSA, submit that new MSA with the new information, and ask that allocation then be reduced as a result. And so there are certain parameters to that. They're looking for a change, significant change, and what's considered significant for them is anything that's $10,000 or 10% different from what the CMS decision originally was. And ways in which you can sort of evidence that, I guess, for example, if it was a spinal cord stimulator, maybe they had the spinal cord stimulator trial after the decision, CMS decision, and that trial failed. That wouldn't be something that would still be valid recommendation. And so we could then take that failed trial as part of the records, incorporate that into a new MSA, go ahead and submit that in order to get a new CMS decision as a result.
Yeah, I mean, I think it's a huge opportunity too on those older cases that still, like, even if you got an MSA approval, quote unquote, in 2008, it's still eligible for amended review. And now we're 17 years later. So that 17 years difference is like a whole new MSA for sure. The hardest thing is trying to actually gather the information from the original submission. Those are some of the details around the amended review process that make it really challenging to settle those types of cases. Because to your point, like, so what are some of the things that you have to think about when you submit that amended review? It is in fact, you have to submit the prior submitted data, right?
You do, yeah. You need to submit all records that were included within the original submission. So like you said, those older files, those can get pretty sticky. I mean, another aspect to those older files is these can't be claims that have already settled. So if you've already settled, then the amended review is not an option. And so these are kind of things to think about once you're looking at that as an option.
Right. If you were saying like it's a 2011 claim, your 2009 claim, say, or should say submission on like say a 2004 claim. The 2009 submission, great. You can, it's definitely can be updated now, 15 years later, but back in 2009, most likely the submitter was submitting it on a disk. They weren't submitting it via a portal. Where's the disk? Somebody in their IT department told them to destroy that record, 5 years ago.
Yeah. Yeah, that can be really difficult then to get those records. I think that's all we have for this one. I don't know if we want to move on to some of our Q&As. These are actual questions that we got in our own inboxes that we decided to kind of pop up here. I don't know if you want me to jump into the first one, Marty, I can do that. So
yeah, and obviously anybody can send any questions you like in the chat box right now, and we'll take them live.
Yeah. So this first one, the question says, we're settling a denied claim. We made one payment of initial compensation while the claim was being investigated. This is an Iowa claim. Can we get a 0 MSA? So this is a great question. And again, this leans back towards the 0 MSA. This looks like it's leaning towards a legal 0, what we call legal 0, because it's a denied claim. Again, we're staying within the four corners of what that means in order to be compliant. And so right now, they're sort of leaning on the fact that this was under investigation, right? So that's one of the four, which is you have a claim where there was maybe a payment without prejudice statute that they've followed, and so they feel like this should qualify as a 0. However, the caveat here is that they say it's Iowa, an Iowa claim. Now, Iowa does not have a specific pay without prejudice safe harbor statute. Not all states do. However, that does not bar them from, providing clear reservation of rights to contest the claim's compensability. And this is where, a hearing on the merits would come in, something like that. So again, kind of looking at your case, again, we're going to bring it all back to the fingerprint. I'm going to trademark that for going forward. But this is sort of like,
I'm feeling it, Neha. I'm feeling it. Everyone's going to witness this theft in real time.
You can have it. It would be an early Christmas gift for you. So, yeah, so that's sort of where this one would fall, right? Because we can't really go the payment without prejudice statute route. Maybe we could go here on the merits route. But another suggestion which came about here was requesting reimbursement of that one payment, in order to kind of have a clean payment ledger, because they're saying that maybe it was under investigation or it was an error or what have you. We've seen that work in the past. So there's different options. And I think if, any of you out there have a claim that you've denied and you're kind of wondering what your options are, send it on over to us. Let us evaluate it. Let us see what's going on. Because there's always options. It's not just, sort of a cookie cutter, one size fits all, in order to kind of get these claims where you need to be, so you can kind of settle them out.
Yeah, and ultimately you're professional, right? So, you've been doing this for, I won't say how long, and all the other
Thank
folks
you.
in our team have been doing it for we won't say how long. So looking at that, and thinking about that, we're the folks who really do kind of get it, right? Like, so we understand your pain. You'd like to be able to settle this case in a certain way. We're taking that under, advisement, so to speak, and we're certainly, looking at the claim in a very sort of like whole picture way to try to get it so that you can settle the case and feel comfortable, and that we can provide you an opinion that's going to work for you. There's going to be advice that's going to go with that, though. It's not something that, to your point, Neha, that like we just will rubber stamp, for lack of a better word.
Right. Yeah,
Okay,
for
so I'll
sure.
take the next one here. So we have an accepted case where the injured worker is a Medicare beneficiary. This one's an easy one. If we settle below $25,000, is an MSA required? So, good question. Is an MSA required? An MSA is never required under any circumstances, even if the case was settling for $1 trillion. So required is sort of like the key word here. It's it's worth remembering. It's never required. It's never required. Doesn't required under the statute is sort of a magic word. So it's not required. However, it is recommended that you do something to consider and protect Medicare's interests. And so even on those cases that settle below $25,000, and depending upon your organization's response to that, maybe to get an MSA. Your organization's response to that, maybe to contact your local ECS representative and get a future medical allocation. Or your organization's response to that might be to say, well, we trust you as the adjuster to work together with defense counsel and claimants counsel to figure this out. But at the end of the day, you can't do nothing. That's the key phrase that I think that we've taken away from this entire year, which is with regard to future medicals, you can't do nothing. You can't just ignore the issue. Regardless of the amount of your settlement, you have to do something, because ultimately the amount that you decide to do for a future medical will be transparent to Medicare.
Right. And I think that's the key there, Marty, too, because we see this question come up a lot, because that 25K has been tossed around for, a decade now, because it's the submission threshold amount, right? But regardless of the submission threshold amount, because we have a Medicare Benny here, that MSA amount is going to be reported regardless of whether you even obtain an MSA. So in the interest of protecting Medicare and accurately funding a future medical component, the recommendation would be to procure an MSA. I guess a little aside on this one, or an extra, is that given that the total settlement amount is below threshold, this MSA could come in the form of a future medical allocation, right? So there's different, again, looking at the MSA varieties, bringing it back to that, recommending an MSA, but what type of MSA? Again, these are fingerprint files. This is not cookie cutter. And sort of kind of following that line of thought.
Absolutely. So this last question, and then we have a couple of questions that are coming through the chat box that Adrian will get to. But the next one, this last question that we've got here for common question is, this is one that I fielded yesterday. So we brought it up. We have a generic version of a high cost brand name drug that just came onto the market. So now it's much cheaper. Can we submit amended reviews on the files that make that switch? And this is always one of the caveats to the amended review thing, right, Neha? We're looking at that. You can do it, but it better not be just because of that, right?
Yeah, absolutely. I love this question because it kind of puts everything in, right? We're talking about amended reviews, we're talking about generic drugs, but per the work comp reference guide specifically states no, that the approval of a new generic version of a medication by the FDA does not constitute a reason to request an amended review on its own, right? And the reason, again, going back to, they don't want to have to keep reopening all these claims. They don't really want to or have the time to every time a generic drug hits the market. So they've sort of said, they kind of drew a line in the sand there and said, this is not going to be, a proper means for obtaining amended reviews. Otherwise, they would just be doing those probably, all day. So unfortunately, no, that's not a reason, but that was a great question.
And the way that they could do it would be, our answer is basically, No, not on its own. But if something else changed in the treatment, then
True.
that's great. Then you'll gain the benefit. You'll sort of kill two birds with one stone.
Yeah, you could fold that in as long as it wasn't the sole reason.
That's right.
Yep.
Okay, Adriana, so
Yeah.
we've got a couple of questions in the chat box if you want to kind of dig through and see if you can find any others. But if you want to go ahead, I think I can read them or.
Yeah, so our first question is from Dick. Is it still worth getting a letter from the claimant's doctor stating a spinal cord simulator or a surgery is no longer recommended? Even with those letters, it seems as though CMS is still including them on the CMS-approved MSA.
Okay, yeah. I mean, here I would say it's absolutely worth getting a letter. Again, it comes down to um, the verbiage within that letter. Again, we're looking for very clear, concise language as far as whether or not treatment is still recommended or continues to be recommended. It's where we have that sort of vague waffling that can happen where you see CMS continue to include those treatment recommendations within their decisions. So I'm not sure if you're aligned with that, Marty, but
Yeah, I
that's
agree.
yeah.
I always think it's absolutely worth it. And, we can work together to try to find a way. If we have a letter from the physician, we can work together to try to find a way to help tweak it for sure with you.
Great.
Great, thanks. And then the last question is from Marvin. If an MSA was submitted years ago by a prior handler, the claim did not settle, and now the medical outlook has changed significantly, such as that settlement is being looked at again. Is there any way to get an updated or new MSA approved by CMS without having to submit the likely lost paperwork from the original MSA?
Neha, I'm going to give you this one.
That's of course you are. This is a tough one, right? So just because it was submitted by another handler doesn't mean that we can't then take that file on. We can always do that. We can get a change of submitter letter. I think, the difficult part of this is, where you say likely lost paperwork, we would hope that that's not the case. And there is a lot of hospitality, I think, between some of the vendors, I will say. So in the event that we ever needed to contact, the prior handler and say, do you have a disc? Do you have those records? It's not something that's completely out of the realm of possibility. It does, kind of put a wrench into what we're trying to do. But the fact that, a file was submitted or is either hung up in development or perhaps already a decision was received doesn't mean that we can't then take that file on, do a full review and either get it out of development or go ahead and try to submit for an amended review on any of those files. I don't know if you wanted to add anything to that one, Marty.
Nope, that's perfect.
Thank you for listening to this episode of the ECS on MSP podcast. We look forward to joining you next month for our next episode. For the latest updates and educational content from ECS, please visit our website at examworkscompliance.com. See you next time.